Hello, can you hear me? Please write me if you can hear me. Okay, so first of all, would like to thank you for inviting me to this conference. I'm very sorry to not participate in presence. And let me say that it is very strange since now it seems to myself to be alone, but never mind. I'm very happy in any case to be with you, even if in distance. I would like to greet Professor Bassett and all people there. I can share my screen with my slides. Can you see my slides? Okay, I think I'm sharing with you. Now I would like to start my slides, and my conference will be my speech will be about conflicts between caregivers and parents in the child care relationship, a comparative overview. My focus is under comparative law, especially UK law and Italian one. You know that it's very difficult, especially for parents involved in the tragic situation of very small children with very strong illness. And in this case, the expression of medical informed consent by the representative that are the parents of the infant patients, and there is a sort of risk regarding these decisions, since the parents that are often under big stress, and this decision could be influenced by medical paternalism. Since the relationship between doctor-adult patient is very different, is a bilateral, and it is very different with the relationship among parent, children, especially children older than 12 years old, and physicians. And in this case, there is a strong influence of a power relationship, much more than in relationship among adults. And this is typical of medical paternalism. The main point in my relationship is protecting the best interest of the child. What's happened in case of controversy among parents and physician about the health of the informed consent expression of a very young child? In most controversial cases, especially in UK case law, medical trials are on very rare diseases represents the last hope of parents. And the medical trials in this case represents the last resort. And there are two big points. On one hand, a scarcity of drugs studied and focus on children. And on the other hand, parents often don't want that their own children are involved in medical trials. And the point is that children facing, in some cases, death, literally. So here we have some screenshots about controversy among parents and physicians and health authorities, especially in UK. You know, I'm quite sure that you remember Charles Gard case, Alfie Evans, or the last one, Archie Battersby. And in this case, the controversy among parents and physicians and health authorities were very strong, and these cases went in courts, and in the UK courts, with the exception of Tafida Rakib case, courts established in favor of the opinion of physician. Even in Italy, we had recently a case of stress, of controversy between physicians and parents. And in this case, it was about COVID test for accepting a child in a specific hospital for taking care of the heart disease of the child. And what is the different between this case and the UK ones is that the public prosecutor applied criminal cases law, and it represents a sort of strong process in the relationship among these parties, since it let the judges to decide in advance in comparison of a civil process. So I said that there is a difficult balance, so a sort of irrational, since it is very emotional point, act occurs. On one hand, there is the risk of the child to be treated as a guinea pig, and this is the main reason, since under it the parents refuse often to let their children to be involved in clinical trials. But on the other hand, the certainty of the child's death occurring with a short time. So a sort of relevant and difficult decision need to be established. And in this case, the point is who decides, or better, which decision. And in this case, scientific research ethics require that the best interest of the child take precedence over the concept of autonomy. Parents and researchers play a different role in pediatric ethics compared to the ethics of the consent expressed by adults. In this case, the point is not who decides, but which decision is the best of the child. In these cases, we have a sort of competition between protection of the children involved in these controversial cases, but on the other hand, we have a sort of necessity of progress, and this is relevant for other prospective cases, because the hope of the advance of science and this discovery of new therapy for the children diseases is one of the points that has to take in care. So I already said that there is a low number of drugs for infants, since the main reason is that drugs for children are very difficult to be developed, and in some cases, drugs for adults may be prescribed to infants. Even this could represent a serious risk for the youngest patients. And other point is discussing therapeutic decisions. It would be necessary to distinguish off-label drugs from off-knowledge ones, whose effects are completely unknown. Physicians will be required to discuss therapeutic decisions thoroughly with the parents or infant patients, but this situation could be very controversial, and since the different physiology that characterize the children in difference from adults. Trials involving them and the follow-up of innovative treatment require a longer time to verify the consequences and side effects of experimental treatments administered to children. Risks and benefits. The relationship between the level of risk in trials and the vagueness of the risk itself cannot always be fully known because of the few children involved in trials, in pediatric trials. This aspect is a part of the principle of justice, which in clinical trials indicates that the risk and the benefits of research must be distributed fairly and not disproportionately among the participants. And as I noted before, the consent for recruitment in clinical trials is a huge point. And this represents a significant problem given the difficulty in obtaining parental consent for recruitment into pediatric clinical trials. In innovative treatment, the relationship between the parents and the infant patients and the medical staff conducting the research is essential. So essential that if there is a disagreement between clinicians, this must be resolved. If this disagreement disrupt the conduct of the trial, the trial must be stopped. This because the research must be done in authentic pursuit of answers to valid clinical questions, and patients should not be subjected to research risk in the absence of genuine belief that the answer to the research question is unknown. What I already said before, at the beginning of my speech, there are possible conflicts of interest among parties, since the interest of the children, the interest of the parents, and the interest of the sanitary authorities are in contraposition. And the main one is the best interest of the child, and that in most part of cases, this is in contradiction with the interest of the parents, especially under emotional aspects. But on the other hand, we have interest in economic nature that could also arise, for instance, in fundraising or moral nature that connected with the interruption of medical treatment. And under this point, it's very interesting to investigate how the public opinion, especially after a huge public newspaper or public media campaign, could evolve. Detecting possible conflict of interest of the child perspective representative will be necessary, since divergent interests in both parties might emerge. Indeed, the coincidence between the representative's initiative and the interest of the represented person is not sufficient for excluding conflict of interest. Duties of the parents and duties of society. The infant's parents have the same time and responsibility, the right and the duty to take decisions concerning him or her. On the other hand, there is a public duty of society, understood as a community, to protect children from decisions of their parents that may be dangerous or inappropriate. So this is my presentation. I hope that you can join it, and I wait for your remarks and for your opinions.